tient la parole maintenant Madame Valkova, ministre de la Justice de la République tchèque. Yes, please.
Thank you. Mr. Chairman, Mr. President, dear colleagues, dear friends, ladies and gentlemen, it is a great honor for me to welcome you to the 6th International Conference of the International Juvenile Justice Observatory, which will take place over the next 2 days under the title of Making Deprivation of Children's Liberty a Last Resort towards Evidence-Based Policies on Alternatives, coinciding also with the 25th anniversary of the adoption of the UN Convention on the Rights of the Child. At the outset, I would like to thank our host, the International Juvenile Justice Observatory, for organizing in these times this very important event, as well as for inviting me personally and giving me the opportunity to share my views with you. My speech will be much shorter and more general as the speech of my speakers before me. And as a former colleague, and I hope in the future, again, also your colleague, I would like to point out that I see the necessity to draw attention of politicians to this topic and to these themes in our uncertain developing Europe that in some way danger the results of our works in the past decades. So let me begin with a brief retrospective. After the First World War, a number of European countries decided to establish a specific juvenile justice system. Among them was also the former Czechoslovakia, whose law on juvenile justice entered into force in 1931. In the explanatory report to this law, it states that, and it was in 1931, it has already been recognized by all civilized nations that punishment does not represent a sufficient response to the juvenile criminality. It is also necessary to identify and address the issue at the roots of unlawful behavior of children. We are obliged, in the name of humanity and reasonableness, to deal with this problem appropriately, not only by punishment, since this often proves to be ineffective, unjust, and even dangerous, but rather and foremost by educational measures aiming to the moral advancement and improvement of the child. These arguments retain their relevance today. Moreover, they are further sustained by contemporary research in psychology and neuroscience that continues to show fundamental differences between juvenile and adult minds. According to these findings, the parts of brain that are critical to judgment, foresight, and decision-making are the last to mature and don't develop until late adolescence or early adult. So not only the social reasons, but also the reasons of development of the brain could be seen as a reason of criminal behavior. As a result, adolescents are more prone to peer influence and impulsive behavior and cannot fully understand the consequences of their action. In other words, adolescents are different from adults in ways directly relevant to their capability as well as their capacity for change, and these differences need to be reflected in criminal policy and practice. Of course, it does not mean that states should ignore the unlawful activities of children or that they should respond in a poorly formal manner. At the same time, however, we must also bear in mind that juvenile delinquency is best addressed through a comprehensive system of measures that consider the needs and interests of children with a view to eliminate the root causes of their conflict with the law, as my four speakers mentioned, pointed out. It follows that the detention of children who are accused or found guilty of a break of law should always be a measure of last resort, and alternative sanctions and steps should be preferred. This year, 2014, the Czech Republic has celebrated the 10th anniversary of Juvenile Justice Act that came into force in 2004. The Act covers the issues of criminal liability, criminal proceedings, and types of measures, including criminal sanctions that can be imposed on a juvenile age persons. A common feature and a leading principle appearing in the entire law common to both age groups, regardless of criminal liability, juveniles or children not yet criminally liable, is the emphasis put especially on restorative approaches and alternative methods. This fairly modern and progressive law brought very important changes into penal, criminal policy of the Czech Republic and influenced also the dynamics and structure of our registered juvenile delinquency, in the best sense of view. Data on the trends in registered juvenile delinquency in the Czech Republic in past decade show continuous decrease of absolute numbers of delinquent children and juveniles. What is now even more important is that the relative share of juvenile delinquency on total criminality rates dropped. However, while delinquency rates on the Czech Republic and some other European countries have been decreasing, these rates are still too high, at least for us, criminologists, academics, of course for public, and as well for criminal policy makers, as me, for example, in my post of Ministry of Justice of Czech Republic. The questions concerning juvenile justice have been discussed recently at the 14th Annual Conference of the European Society of Criminology, which took place in September of this year in Prague, with the participation of more than 1,000 professionals from about 50 countries. In the course of this event, several problematic issues existing in certain legal systems were identified. For instance, the absence of child-friendly procedures for juvenile suspects during police interrogations, the practice of sentencing socially excluded children to custody far away from their homes, making it more difficult for them to maintain contact with their families and communities, or the importance of aftercare programs for reducing recidivism among juvenile offenders and promoting their successful reintegration into society. Mr. Chairman, Mr. President, ladies and gentlemen, dear friends, to return back to my initial historical note, according to the first legal commentary to the Czechoslovak law on juvenile justice adopted in 1931, something very similar was in Austria too. It is necessary to perceive the juvenile delinquent not only as a person who should be prosecuted and punished, but first and foremost as an individual in need of help and protection. Today, in 2014, we may add to this proposition that it is our duty as a people in charge of public policies to enable the healthy development of the children as one of the most promising groups in our societies. The best approach is to offer youth who make mistakes, guidance, and support. We know it for decades, for centuries. All children make mistakes, but they are usually able to learn from them and grow into responsible adults. At the same time, it is crucial to ground our discussion about the future of juvenile justice in Europe, and not only in Europe, of course, in a solid evidence-based and shared international experience. And I would like point out not only international exchange of academic knowledges and research results, but also of the issues of criminal policy and support of some joint ideas how to progress and how effective to combat and to struggle with the prejudice and with the populistic views and suggestions how to deal with juvenile criminality. May this conference contribute to this purpose, along with providing fresh perspectives and new ideas. I wish you all a lively and productive discussion. It is now my singular privilege to declare the 6th International Conference of the International Juvenile Justice Observatory officially open. Thank you very much.
Thank you.